Good morning, everyone, and thank you so much for joining us for this post-cabinet briefing. I am Lisa Lord. This morning, we will hear from the Minister of Home Affairs and Information, the Honorable Wilfred Abrams, on matters pertaining to the Child Justice Bill, and then he will entertain some questions. Minister Abrams.
Thank you. Good morning. I am happy to advise that yesterday the Cabinet of Barbados approved and agreed to the laying in Parliament of the Child Justice Bill, which should be the Child Justice Bill 2022. This bill has been some time in the works. In 2019, the decision was taken to harmonize the child protection legislation with the child justice legislation so as not to send the wrong signal and create imbalances. The completion of this suite of legislation has been a priority for this government. Indeed, since assuming office, this government, through the Ministry of Home Affairs and Information and the Ministry of People Empowerment and Elder Affairs, has been working assiduously in collaboration with UNICEF and other stakeholders to fully address the rights and needs of children, and at the same time addressing the deficiencies within the criminal justice system, and specifically the juvenile justice system. To this end, two critical pieces of legislation are going to be engaging the attention of Parliament, and they are the Child Protection Act, which was recently laid in Parliament, and the Child Justice Bill, which has now been agreed by Cabinet to be laid in Parliament, and this will be done in very short order. It is envisaged that the Child Justice Bill will bridge the gaps, the policy gaps, capture the legislative and institutional amendments necessary to provide a holistic approach to the protection of the rights of the child. The Act, once proclaimed, will make provisions for the reform of criminal law applicable to children, and will repeal the Juvenile Offenders Act, Cap 138, and the Reformatory Industrial Schools Act, Cap 169. The Child Justice Bill will be a modern, comprehensive piece of legislation encompassing social justice, which will enable children that become in conflict with the law to still become healthy, productive, and engaged members of society. What is the bill about? Some aspects of the bill. The age of criminal responsibility. A child under the age of 12 years, once this act has been passed, will not be capable of committing an offense, a criminal offense. It also deals with principles to be applied when dealing with children. So the court or any person performing functions pursuant to the provision of the act shall be guided by the following principles. The safety, welfare, and well-being of the child shall be the paramount consideration. A child shall, as far as possible, be given an opportunity to respond before any decision is taken which affects that child. A child shall be addressed in a manner appropriate to his age, maturity, and intellectual development. A child shall be treated in a manner which takes into account his beliefs, and all procedures to be carried out pursuant to this act shall be conducted and completed in a timely manner. The parents and families of a child shall have the right to assist the child in proceedings under this act, and wherever possible to participate in decisions affecting the child. All consequences arising from the commission of an offense by a child shall be proportionate to the circumstances of that child, the nature of the offense and the interests of society, and a child shall not be treated more severely than an adult would in the same circumstances. A child lacking in family support, educational, or employment opportunities shall have equal access to available services, and every effort shall be made to ensure that a child receives equal treatment in relation to other children who have committed similar offenses. Also, at multiple stages of the process, there will be opportunity for diversion from the strict legal processes to an avenue that encourages rehabilitation and seeks to guide the child through a solution that does not subject the child to a full trial and incarceration. This legislation has also been drafted to be fully compliant with various conventions that Barbados is signatory to, as these relate to the rights and protections of children. And these include United Nations Convention on the Rights of the Child, Universal Declaration of Human Rights, United Nations Standard Minimum Rules for the Administration of Juvenile Justice, these are better known as the Beijing Rules, United Nations Rules for the Protection of Juveniles Deprived of their Liberty, and United Nations Guidelines for the Prevention of Juvenile Delinquency, and these are called the RIDA Guidelines. This government, being fully cognizant of and listening to the concerns of the public, has been proactive. Certainly over the last 18 months, The courts have not sent any child to JS for wandering, and the last girl currently with JS is due to be released today. Let me assure all Barbadians and residents that the government remains fully committed to addressing, respecting, and protecting the rights of children. I will provide opportunities wherever possible and wherever needed for children who need counseling and or mentoring. Additionally, safe spaces will be made available for each child to live, play, and grow. The government industrial school will be and is currently being transformed. Appropriate training will be given to staff as required, and persons who possess the right competencies, qualifications, and attitude to work with children will be engaged. This is to ensure that any child who becomes a ward at JAS can and will get the best possible care and opportunities for their development, and to lead at the end of this day to successful reintegration into their homes with their loved ones and society. Thank you.
Thank you, Minister. As we open for questions, I'll just ask my media colleagues to identify themselves and the media house they represent before posing their questions. Colville?
Yes, hi. Colville Manzi from Nation News. You mentioned that the age of culpability under the new legislation would be 12. However, what would be the recourse? I mean, there are some offenses that might be considered heinous committed by a child under 12. What would be the recourse or corrective measures now in place for those children? And secondly, what was the age before before 12, before this legislation is now has now been approved?
All right. The age of criminal responsibility in relation to children depends on a number of factors, right? And it has varied through time. They look at the maturity of the child, they look at other things. What it is right now, to be honest, I probably can't tell you. But to remove all uncertainty and all the other factors that come into play and arguments that be made, the cutoff line under this legislation will be 12. No child under the age of 12 will be deemed capable of being criminally responsible. That does not mean that persons will not have, that the child is going to be ignored. A child can commit a crime or an offense and run free. But in terms of criminal proceedings, you can't institute criminal proceedings against a child under 12. I started by saying that we're looking to harmonize the child protection legislation along with the child justice legislation. If a child under the age of 12 is engaging in behavior that if they were over 12 would be strictly criminal behavior, then you have to look at the circumstances of that child. And at some point in time, although you can't prosecute them for it, the state has to be able to take protective measures in the best interest of the child. So that's where the child protection legislation and all the protocols under there will actually start to kick in. But in terms of trying a child criminally and making the child criminally responsible for the behavior, the cutoff age is now 12. Sorry, 1 second. I'll actually get back to you with what the existing age is.
I'm Chantal Legal-Gisson from StarCon Network. I know you would address the issue of wandering with 18 months waiting period since the last wandering case being called. Some questions in media have been, how is wandering going to be addressed now under this new legislation in terms of the underlying issues that may lead to people wandering in first place?
So, wandering is one of those interesting historical charges, and that was meant to actually control the movement of black people, quite frankly, and black women. Now, our government has been clear from the get-go that it was our intention to remove the charge of wandering from the statute books. When we started drafting the legislation, that question was asked, and we upfront said, if it's one thing that's going to happen with this suite of legislation, is that wandering is not going to be on the books anymore. It's an offensive charge, to me, is an affront to the dignity of people. Worse yet, is an affront to the dignity of women, because a boy cannot be charged with wandering. So wandering is a charge that applies only to girls. And that of itself should start to tell you that that has no place in a modern society. So wandering, the criminal offense of wandering, being out being unable to explain yourself, can't give a valid explanation for it, whatnot. All the things that lead to wandering will not now lead to a charge for wandering. So you can't pick up a child and charge them criminally for wandering. But equally, you can't ignore certain circumstances. If a young child, I'm not even going to say a young girl, because we got to look at the protection of children generally. If a young child is found in a circumstance that is inappropriate for that child, and on the road and hasn't been attending school, all the things that would normally have ticked off the box for wandering, right? Then that child comes to your attention, child protection authorities. And you start by investigating why is the child where the child is, what support does the child or the family need, what can the government do to ensure that the child is protected and that this sort of behavior is encouraged. And all of the things that then fall, all of the avenues that then fall under the child protection legislation will kick in to secure the best possible treatment and the best possible outcome for the child. But what will not happen is that that child will be dragged before a court, possibly on the offense of wandering. So to make it clear, the offense of wandering no longer will form part of the legislative framework of Barbados.
Yes, Minister. These statutes, as outlined, are they now left just to the interpretation and fulfillment of the Child Protective Services, or are we looking towards a juvenile court system? Could you give us some information on that?
But there currently is a juvenile regime. So imagine now that we've wiped away however we used to deal with children. We've now wiped it away. We've looked at the best possible modeling. We've drafted the legislation, both the child protection legislation and the child justice legislation, with very close consultation with UNICEF and all the other stakeholders, all. I mean, down to the point where we had what we figured was the last draft of this piece of legislation, and somebody chimed in very, very late with some amendments that they wanted. And whereas we could have run it and then sought to deal with those afterwards, we wanted, when we presented this bill, to have the best possible piece of legislation, and we took those into consideration. It then delayed our ability to get to this point, right? But all of the things that affect children now come into play. We spoke about even the way you deal with a child in court. If a child has to come to court, then the child is not going to hear the charge in the same way that a charge is read to an adult. The charge will be put to a child in language that is child-friendly and that the child can understand. And it depends on the maturity level and intellectual level of the child. Even the proceedings, you won't have strictly adversarial proceedings in court. The proceedings are meant to get to the bottom of what is happening, right, and to assist the child. So I spoke about diversion. What does diversion look like? At about 5 different stages in the criminal process. Right now, if a child is picked up for doing something illegal, the child will go through the exact same procedure as is met with for an adult. The child will be questioned, give a statement in the presence of their parent or some responsible adult. The child will be charged, appear in the dock, and the same rules that apply to adults apply pretty much to children. No. The intention now is to do everything possible to take the child out of the criminal justice system. So at the point when the initial report is made, right, the police can recommend a diversion from going along strictly legal lines or charging the child to perhaps recommend that the child would better engage the attention of the child protective services. When you come into court, there are a couple different points in the court process where either the prosecutor or the magistrate can recommend diversion. So let's pause this criminal process and let us send this child for drug counseling. Let us send this child to the protection services. Let us send this child to a psychologist and evaluate. So that the only time a child will get to the end of the criminal process and then go to the government industrial school would be if all other attempts to find some other means to deal with the matter in a way that that preserves the best interest of the child and aims at a successful reintegration with the family, with society, and the development of the child have failed. So a lot of the things that the framework now requires a child is either you go back to your family or you go to the government industrial school. No, that's going to be widened. There's going to be a lot more power by the authorities to protect the child, to seek assistance for the child, to monitor the child, than currently exists. So it's an entirely different framework. It is a 20. By the time these pass, these will be the two most modern and comprehensive pieces of legislation dealing with child protection and child justice in the world. So even when we were drafting, they started with model legislation, and somewhere in there, right, the last bit of legislation where it was enacted, in using it, they brought some difficulties. So those difficulties were then corrected in hours, or account was taken of those difficulties, and further drafting was done to ensure that doesn't happen in Barbados. So when this passes, Barbados will have the most comprehensive suite of legislation dealing with children in the world.
So, Hoyt, CBC News. Minister Abrams, just last week in the High Court, wandering was struck down as unconstitutional. And as a result, 2 former female warriors were also rewarded damages in over $200,000. Does that ruling open the floodgate for other former warriors, and how will government respond to that?
So right now, a stay has been granted in that. The fact that a judgment is given doesn't mean necessarily takes effect immediately. Either of the parties can apply for a stay in the execution of the judgment while you consider your options. The government has applied for a stay in relation to that, and it is considering its options in relation to the judgment. What I want to make clear is that I've spoken to the AG. It is not intended at all to touch or contest the part that deals with the unconstitutionality of it. We agree with the judge. We accept that it has to go. The fact that our legislation, which was obviously in draft well before these cases came up, have done away with wandering means that we can't contest it. It is unfair, it is unconstitutional, it should not have happened, it should not have been here as long as it has been. We are happy to see it go. So we're not touching that part of it. But as you said, there are other considerations that have to be taken into account in relation to the other aspects of the decision of the judge. And we're taking advice on it now as to what happens next. But there will, I want, for the avoidance of any doubt, there will be no appeal as to the constitutionality aspect of wandering. That was probably the safest decision any judge could have made in Barbados at this given time. We said it at the beginning that we're doing away with wandering. We said it over and over in interviews, we're doing away with wandering. When Minister Humphrey laid his child protection legislation in Parliament, he said that wandering is going to be done away with, and pointed to the fact that when the child justice legislation is done, the consequential reforms of other pieces of legislation are going to do away with wandering. So there can be nobody in Barbados who can doubt this government's commitment to see the end of that centuries-old charge of wandering. So we accept that on the part of the judge, but we consider options in relation to the rest. As you understand, it will have certain other consequences. So those, we have to consider those very carefully.
So the application of the stay is in relation to what exactly?
The application of the stay is in relation to the judgment, right? It's just how the application stays in relation to the judgment. But I'm telling you up front, because I don't want anybody to take from this that we're challenging the validity of the ruling with respect to his declaration that wandering is unconstitutional. The charge of wandering is unconstitutional, right? So we're not attempting to reinstitute that. We're not attempting to appeal that, saying it was wrong. The fact that I'm here talking to you all now about the child justice legislation, telling you we're done with wandering. We, the government of Barbados, want to see the back of wandering. We're committed to it, and as far as we are concerned, we're done with that. As I said, if you even think about it, nobody's been remanded to the government's industrial school recently in relation to wandering. Although we had not gotten the legislation done yet, every young person who was in there, that there was a discretion to release them, either early release or whatever factors, that there was a discretion to release them, who was serving time or there as a result of a charge of wandering, has been released. The last person, I can't give her name, the last person, her time frame for early release, the consideration for early release came up this week. and she going home, hopefully, today. So we've not been playing with it. The law, we took a while to get here because legislative drafting is a complex thing. And we couldn't rush that one. We had to do it with the stakeholders. We had to do it to make sure we're compliant with UNICEF. We had to do it to make sure the government satisfied all of its obligations to children and to our international treaties, right? The difference between a judge and parliament, a judge can make a decree and immediately strike down something, which is what he did. But his timeline happens to coincide with ours. So I just want everybody to be clear on that. There's no attempt by this government to preserve or reintroduce wandering. Wandering is a thing of the past.
So the state is in relation to the damages? Just trying to get this clear, really.
What is being contemplated now and we're taking advice on is in relation to the damages aspect of it.
Thank you.
Is that clear?
So the final question will go to Anesta Henry from Barbados.
Right. Good morning, Minister. This week, parliamentarian Marshall Cattle would have called for corporal punishment in schools to be done with. What are your thoughts on her call?
Marsha, as a member of this government, everybody's encouraged in this government to be able to embrace their views, right? And we will not always have the exact same view. I'm not saying that my view is different to hers, but as a minister, I have to also consider and factor the collective responsibility of cabinet. So as a minister, I'm not at liberty to even tender my own personal view at this point in time. That is something that has to be contemplated and dealt with by the government in terms of reform of legislation, if necessary. So Minister Cattle is known for speaking her mind, right? And she is in a position to do so. Sorry, backtrack. MP Cattle. I said Minister Cattle.
I just want to do a quick follow-up. Under the Child Protection Act then, would education be factoring, going back to the same corporal punishment, would that be something that would be factoring in terms of being placed or something you'll be focusing on under the Child Protection Act?
Yes. So right now, persons who wards of the government industrial school do get educated. Their education is supposed to continue in the government industrial school. But we're looking at the reality of the situation. A lot more options are available to us now. With COVID, we saw remote learning, we saw remote interviews, we saw other options. There is going to be a heavy push to ensure that any child who comes into contact with the system gets the best possible outcome out of it. And that includes educational opportunities. That includes assessment of the children, that this child might not be necessarily be academically inclined, but might have another skill set that should be encouraged. And all avenues for the development of the child are going to be encouraged. And we're going to try as much as possible. Any child who becomes a ward or under the protection of the state comes out in a much better position or emerges in a much better position and better equipped to deal with the challenges that brought them to our attention and better equipped to deal with life challenges so that they have the best possible chance at success out in the world.
You had any final comments, Minister? To summarize?
Yeah. So, in summary, this government has always been committed to the rights of children and the protection of children. If it is one thing that we are bent on, you've heard it from the Prime Minister, you've heard it from the Deputy Prime Minister, you've heard it from the Attorney General, you've probably heard it from every member of this government. We are committed to protecting the rights of the child and securing the best possible opportunities for our children. That's why you're seeing things in relation to educational reform. That's why you're seeing the youth programs. That's why you're seeing all those interventions. That's why you're seeing the creation of the clean and green spaces, right? That's why you're seeing the lights on the playing fields. All of these things are meant to guide our young people and provide positive opportunities for our young people to develop themselves. The child protection legislation and the child justice legislation it is another step in that direction. I think this brings us kicking and screaming into this century in terms of what the best practices are in relation to children, the welfare of children, the education of children, and the opportunities for children. And I am comfortable that right now in front of us, we have the best possible piece of legislation, having been settled with the stakeholders, having been subject to comments from every single area of Barbados that is concerned about the welfare of children. We've taken all comments into consideration, but even so, once this legislation is laid, it's going to go to select committee. So there will still be further opportunities for persons to chime in and other things to be taken into consideration. But we are formally putting it before Parliament and saying we think right now we have done our duty by the children of Barbados and created the legislative framework that we believe best encompasses the government's perspective on it and best secures the protection, welfare, advancement, and best possible opportunities for children in Barbados. So my conscience is clear right now.
Thank you very much, Minister. That was the Minister of Home Affairs and Information, the Honourable Wilfred Abrams. Let me also thank my colleagues in the media and you for joining. Do have yourself a fantastic Friday.